This is the beginning of part 2 of what we're covering in the Australian legal system. This is the part of the course where we start to look at what I call the nuts and bolts. That is, where we need to have an understanding of those practical skills that lawyers use on a daily basis. Those skills involve having an understanding of how to interpret a statute and also how to understand a case and analyse a case and see how judges make decisions. So today we focus on statutory interpretation. And the reason that it's important for us to have an understanding of statutory interpretation, as I said, is that these are the tools that lawyers use. We also need to understand the rules of statutory interpretation within the broader social justice content. And thirdly, the politics of interpretation. You'll see when we work through this today that there are choices as to how one interprets the words. Statutes and delegated legislation are the principal source of all new law in all modern legal systems. If one were to conduct a survey of all legal rulings made in all of the reported cases to be found in the entire law library collection, judicial opinions on the meaning of words in legislation would top the poll. That in itself is a good enough reason to have some understanding of how to interpret a statute. As we've already discussed, legislation affects much of our activities on a day-to-day basis. Knowing the rules used to interpret legislation is a valuable skill for us to grasp, let alone understanding that it's the tool of lawyers. Of course, lawyers have a highly developed knowledge and application of these skills. Your skill level will also develop as we work through this part of the course. Statutory interpretation is governed by rules, and we need to think about these rules in terms of justice. As I say, as legal studies scholars, we are interested in justice. The first rule of statutory interpretation is that statutory interpretation must be such that you construe the statute as a whole. We also want to know what Parliament intended the statute to do and who the target audience is. But, as I said, these rules cannot be considered in absence of justice, because to learn the rules of statutory interpretation is much more than learning an exercise. The rules apply to human beings, and it's not just a matter of semantics. Applying the rules to human beings' lives may change their lives through the interpretation over time. For some, it may mean a deprivation of liberty, with the freedom to engage in many activities taken for granted being curtailed for a substantial period of time. So how do we then know if an interpretation of the words is just? Well, again, I must say that, like with a lot of other aspects of this subject area, a knowledge of justice develops over time and becomes more sophisticated with the learning and thinking you embark upon throughout this course and for the rest of your life. It takes years to develop an understanding of justice. We also need to consider the politics of interpretation. As I said, when you're interpreting the words of a statute, there's a choice. Which way will you read and interpret a word? Could you read it this way, or could you possibly read it that way? How you interpret the word will go back to your sense of justice. And it's in this sense that your own values will come into play. Because when we look at case examples for this topic, it will become more apparent that you do indeed bring a sense of justice to bear upon the words. Well, our starting point with considering statutory interpretation is first of all to have a look at a statute itself and to gain an understanding simply of what the various parts of the statute are. Now, this is a Victorian Act that we're looking at today, and you can see that it is the Prostitution Control Act of 1994. You can see the title of the Act there as we go through. And notice the comment at the very top here on the layout of an Act, that since September 1985, Victorian Acts have appeared somewhat different to Acts passed in other states. The traditional short and long titles have been replaced with a single title and a purpose clause. What is the coat of arms for South Australia? See if you can find out before your next workshop and let your workshop facilitators know. I wonder how many of you really do know. All right, we see as we move down the statute that all acts have a number, and the act can be identified by its number, although it's more common to refer to it by the title. So, as I said, you would ordinarily refer to this as the Prostitution Control Act of 1994, but you could, if need be, refer to it as Act number 102 of 1994. Note underneath the title of the Act, we have some information that tells us that the Act was assented to on the 13th of December 1994. Note again the commentary which indicates that the date is the date which the Governor assented to the Act, and that the Act will come into force 28 days after the assent, unless a contrary intention appears in the Act. So every aspect of a statute is important to look at. And that's why I would urge you all not to only rely on accessing acts through electronic material exclusively, because you won't get to see the Act in full as we are today. You'll also be undertaking law library research this semester, and that will bring you into close contact with the material so that you will be able to see the statute as a whole as we're showing you today. Now, note as we proceed down this first page, we come to Part 1, Preliminary. And you'll see here that an Act is made up of sections which can be divided into subsections, paragraphs and subparagraphs. For example, you're given see Section 23 of the Prostitution Control Act 1994. If you have the Act in front of you, as I say, you can work through this, where you will go through every section of the Act, see how it's divided up into parts, see what schedules there are, and you'll see when you go through Acts as well that there are often comments down on the side margin. It's also important to look at those. Note as we move forward, we have the headings. The purpose of the Act. What is the purpose of the Act is something we will always want to know. Here we have comments which tell us the main purpose of this Act is to seek to control prostitution in Victoria. The Act amends the Crimes Act 1958 to create a new offence related to child sex tourism, and amends the Travel Agents Act 1986 to provide for the disqualification of licensed travel agents who are convicted of offences against that provision or the similar provisions contained in the Crimes Act 1914 of the Commonwealth. So the purpose of this Act is made very clear. It's to control prostitution in Victoria, but it amends a number of other acts as well. So clearly you have a lot of information just there in that one section at the very beginning, which tells us what the purpose of the Act is. You'll see here that we also have a comment that most Acts now commence every section with a heading which provides some limited information as to the content of the section. That's to make reading through the Act as simple as possible. Once you start interpreting the words of the Act, you need to ponder very carefully. To gain a quick overview of what the Act is about, it's very helpful to look at those headings as a guide to direct you to what you need to go to as quickly as you can. We also have comments here about the purpose clause in the Act. And note it says that Victorian Acts now all include a purpose clause. In other states, similar clauses, sometimes called object clauses, are becoming increasingly common. These clauses are useful indicators of the Parliament's intention, and for this reason they are often used in statutory interpretation. Most important to note what you can and what you cannot use to interpret a statute. Quite clearly here, as with any statute, you need to find out what the purpose or the object of the statute is. That helps you and guides you to interpreting the words in the statute itself. You'll also note that the layout of an Act may vary from time to time. For example, you might find quite a lengthy preamble at the beginning of an Act, whereas that is obviously not the case in our current example. Well, given that we now know that it's very important in interpreting a statute to first of all look at the various parts of the layout of the Act, we then move to thinking about how we actually interpret the Act as a whole. Because when an individual is charged according to an Act, the first thing the court has to do is interpret the words. But where do you find the meanings of the words? Your starting point is with intrinsic materials. That is, what do the words say when we literally interpret them? If there are technical words in an Act, you might find that they've been interpreted in the interpretation section of the Act. I'll give you an example of that a little further on. But you might also find that you need to go to a dictionary definition at this point. So remember, the aim of the court is to interpret the statute to ascertain the object and the purpose of the statute. In our Prostitution Act, we saw, of course, that you had the purpose of the Act identified at the very beginning. That may not be the case with all legislation that you will have a look at. I will say again that it is important for the court to interpret the statute to ascertaining the object and the purpose of the statute. Because, as I've mentioned before, we are talking about justice, the loss of liberty for people at times, various other sanctions that will be applied depending on how one interprets the Act. We are given some guidance through the Acts, Interpretation Acts of the Commonwealth and States and the ACT, which indicate how certain words are. So far we've got to a point where we've looked at the text of the statute and consulted a dictionary. When we need to look at the rules of statutory interpretation, we need to think about the rules of presumption. We also may need to consider extrinsic materials. These might include other cases, where you're examining what other judges have said about particular words, or you might also consider other legislation. Much of legal reasoning is based on analysis, which considers matters such as, does that case throw light on how the words might be used in this case? And remember that the lawyer is also acting as an advocate. If the law appears unjust, who is the law unjust for? The good advocate will select cases to draw out points which will support his or her client's case. All right, let's look at a section of the statute now to make some sense of what we've been discussing to date. And I'm going to look at the Summary Offences Act. This is a South Australian Act. And note what I said before, how you actually receive the information electronically. You don't get the statute in the complete form that you do when you go into the library. All right, we're looking at the Summary Offences Act 1953, Section 22, where it deals with indecent language. A person who uses indecent or profane language or sings any indecent or profane song or ballad in a public place or in a police station, or which is audible from a public place, or which is audible in neighbouring or adjoining occupied premises, or with intent to offend or insult any person, is guilty of an offence. And the penalty here is $250. In this section, indecent includes obscene. So, what are the words that interest us? Indecent or profane language, or sings any indecent or profane song or ballad. Well, what exactly does that mean? What do these mean within the context of the statute? Well, if we were to think about this literally, as I said, we may first of all go to a dictionary definition to have a look at what the word indecent might mean, let's say, for example. In this instance, I went to the Collins Oxford Dictionary of 1978 at page 383 and found the word indecent, which is described as not decent, specifically. A, not proper and fitting, unseemly, or B, morally offensive, obscene. Well, does this help your client? Good advocates will go to the problem area of the statute in regard to the client. In other words, what words are problematic for your client? Well, the person's been charged with indecent language, but it includes singing any indecent or profane song or ballad in the following situations. Well, that raises a number of questions for us. Our young client in this instance has been singing a rap song as he's walking down Rundle Mall. Is Rundle Mall a public place? Do we know definitely in our minds what a public place is? In this particular Summary Offences Act, we have an interpretation section. I mentioned to you before that you may find an interpretation of relevant words. Now, public place includes a place to which free access is permitted to the public with the express or tacit consent of the owner or occupier of that place. B, a place to which the public are admitted on payment of money, the test of admittance being the payment of money only, and a road, street, footway, court, alley or thoroughfare which the public are allowed to use, notwithstanding that road, street, footway, court, alley or thoroughfare is on private property. So you can see when you start looking at interpreting the words in terms of the intention of the statute, public place may mean something different to what you would ordinarily think about as a public place. Well, it would seem with our young client walking down Rundle Mall that the person is in fact in a public place. However, are they using indecent or profane language or singing any indecent or profane song or ballad? They may be in a public place, but are they in fact breaching Section 22 of the Summary Offences Act? Well, if the literal rule is not clear, that is, if our looking at the ordinary words in the Act and interpreting them in an ordinary way, if there's some ambiguity then in the word itself, then the golden rule is applied. We need to consider the purpose of the Act. In this instance, we don't have the purpose of the Act in front of us on the front page as we did with the Prostitution Act. By applying the golden rule, we're attempting to glean what is the true meaning of the word in the terms of the Act. My dictionary definition. My dictionary was from 1978. We know that indecent or interpretations of indecent may differ with periods of time. It's seen within its social context. If I was to go swimming in a very brief pair of shorts at another period of time, it would have been considered indecent. Today it is not. So it is relevant to consider the word within the confines of the Act, and obviously the Act comes out to deal with particular behaviour within the social context of the time. So would I be better going to a current dictionary to consider indecency in light of today's moral standards? Is there a difference? I'll leave you that to consider yourself. In fact, it would be a very good idea if you had a look at a very recent dictionary and just see, is the definition of indecent exactly the same? If it is, what's morally offensive and obscene today? Is it the same today as it would have been in 1953 when this Act came out? What's the sort of behaviour that is trying to be captured by the Act? The purpose of the Summary Offences Act is to stop people being offended. So to gain a fuller understanding of the context in which the statute was written, we might also do some other things. We might look at parliamentary debates, and we might also consider what other judges have said about the Act. So to undertake this sort of exercise, you need to be developing your library research skills to obtain this sort of information. By considering debate about the meaning of the Act, it will relate to its purpose and how it's to be interpreted at this point of time. Let's have a look now at another Act, which is a Commonwealth Act, and this is the Social Security Act of 1991. Now, this is an Act that will have impact on a number of people in society, and the purpose of the Social Security Act is to benefit people. That is, it's aimed to be helpful, and you need to have an understanding of that when we start to look at the behaviour that people engage in and how the Act is interpreted. So we see here 54(2)(b)(1), and notice we have subsections here as well that we can look at. which all help us to gain an understanding of the Act. A person ceases to have a temporary incapacity exemption if the Secretary is of the opinion that the person should, 1, contact a particular officer of the department, or 2, attend an interview at a particular place, or 3, complete a questionnaire, or 4, attend a medical, psychiatric or psychological examination. So, failure to attend an interview may result in a cessation of temporary incapacity exemption. So we have some situations where we can see that you can be exempt from receiving a sanction of any sort for not attending an interview. Note that it says that the exemption is based on the opinion of the Secretary. Let's think about how this might actually work in practice. Let's think about an example for a moment and say if you're attending Centrelink for an appointment, your benefit may be revoked if you're not there on time. Now, it has to be, obviously, due to one of these social circumstances. Now, let's look at 1. The Secretary is of the opinion that the person should contact a particular officer of the department or attend an interview at a particular place or complete a questionnaire or attend a medical examination, etc. All right, what does fail to attend the interview actually mean? How do we interpret this in light of the purpose of the Act? If you're 1 minute late, should that be interpreted as not attending your appointment? What about if you're an hour late? A day? You can see, just from this very small example, that there are ways of being able to interpret the words. For us to interpret those words clearly, we need to go back to what the purpose of the Act is about. The aim of the Social Security Act is to benefit people. That is to help them in some way. Now, clearly, when we're considering somebody not being there for appointment, you need to consider that action or lack of action in relation to the purpose of the Act and consider what is reasonable in the circumstances. There's that word that I said will come up time and time again, the word reasonable. What is reasonable in the circumstances? If a person's car breaks down and they genuinely can't get there on time, does that mean that that person should suffer for that? Unlikely. It still is subjective. What one person sees is reasonable in the circumstances, another person might think is pushing the matter to extreme. But you would always have to take the purpose of the Act and keep that uppermost in your mind when you are considering a situation such as that.